Hi everyone, and welcome to today's session, our Mayday GDPR webinar. It's great to see so many familiar names here in the attendees and also some new people. So hi everyone, I'm Lizzie, I'm the Client Services Manager here at Liveminds. In our GDPR session today, Dr. Inga Kroener will provide us with an overview of the main changes for the market research sector and the biggest issues that companies operating in the sector need to think about, and then we'll follow up with a Q&A session afterwards. Before we begin, there's a couple of housekeeping points for you to be aware of. We've received lots of questions already, but if you do like to submit anything that you think of during the session, please do use the questions section on the webinar sidebar or use hashtag MaydayGDPR on Twitter. We'll also be sending out a recorded version of this session, minus the Q&As at the end, together with the presentation slides in the next few days. So for those that aren't familiar with us already, Liveminds is a research technology company. We have our behavioural recruitment service, which provides fresh participants for research matched from 2 billion people worldwide. It's a radically different approach, and it's powered by live social data. So we don't have a database, we find fresh participants for every project. Our research has shown that these participants give 47% more data than those that are recruited through traditional methods. And of course, we also have our simple mobile online qual platform, which gets researchers closer to our participants with mobile apps that work offline and on, and also so they can capture any moment, and also HD video to vividly bring all these insights to life. We also have 33 languages on the platform covering 4 billion people all around the world. So now I'd like to introduce you and hand over to today's presenter, Dr. Inga Kroener, Protection and Privacy Consultant at Qualog. Inga has over 12 years' experience working in the area of data protection and privacy in relation to new and emerging technologies. Her most recent role involved providing data protection consultancy services to a variety of global organisations. She has experience of conducting data protection impact assessments and privacy impact assessments, including providing recommendations for developing organisation-wide robust privacy and data protection programmes. She's experienced in providing assessments and advice relating to GDPR, the UK Data Protection Act 1998, EC directives and the Privacy and Electronic Communications regulations in the UK. She also has an in-depth knowledge of a variety of other legislative frameworks and standards. Inga is a certified information privacy professional for Europe, and she is an ISO 27001 certified information security management system lead implementer, which is a bit of a mouthful. well, great. Without further ado, I'd like to introduce Inga, and she will take you through a presentation.
Okay, so talking generally about the GDPR, I'm sure you're all aware of what the acronym stands for, but I do still see misspelling, so we'll just run through what it actually stands for. So it's the General Data Protection Regulation. It has been in effect since 2016, but it becomes enforceable on the 25th of May this year. So it's an evolution of a kind of a harmonised approach to data protection across the European Union and the EEA countries. So there are some new bits and pieces in there, but a lot of it has actually been around since the 95/46 EC directive. So a lot of the fundamental principles have been around for a long time. Those have then been enacted in country-specific legislation, such as here in the UK, we have the UK 1998 Data Protection Act. At the moment, we still have some changes coming through in the UK for the new data protection bill that will also become enforceable on the 25th of May 2018. So that supersedes the UK 98 DPA as it stands. And obviously all of the countries across the European Union will also be enacting their country-specific regulation at that point. But the General Data Protection Regulation, the point of it is to create this overarching harmonised approach with a minimum standard for data protection across the EU and the EEA. So in terms of who it applies to and the territorial scope of the GDPR, it applies if the controller, the data controller or the data processor is established in the Union, regardless of where the processing takes place. So if you have a company office or headquarters in the European Union, but your servers are located in the US or other countries outside of the EEA, the GDPR still applies to you. Secondly, it applies if processing personal data of data subjects in the Union. And that is the term that is contained contained in the GDPR. So you might see people talking about EU citizens or EU residents and whatever else. That really just confuses things. So if we talk about EU data subjects, so it's any data subjects, any individuals who are in the European Union and the EEA, within those boundaries. So if an EU citizen travels to Namibia, for example, the GDPR is not going to apply to a company in Namibia or a hotel in Namibia processing that data of an EU citizen or resident, unless any of the other reasons why you would need to apply to abide by GDPR apply. So that's the second one. If processing the personal data of subjects in the Union by a controller or processor not established in the Union, where the processing is related to offering goods or services to data subjects in the Union or monitoring their behaviour. So it also applies to, for example, a US-based company who is marketing goods and services to data subjects in the European Union. And then thirdly, it also applies where member state law applies by virtue of international public law. So for example, it will apply in the Canary Islands because Canary Islands and Spain. So you would also have to abide by the GDPR in that case. In terms of the material scope of the GDPR, so it applies to any processing of personal data that happens wholly or partly by automated means, and then also to the processing that isn't by automated means, but that forms part of a filing system or is intended to form part of a filing system. So that will also include pieces of paper that are filed away. It doesn't apply to purely household or personal activity, so we don't need to worry about that in terms of like personal use of things like Facebook or whatever else. That will carry on as before. A very important point, GDPR really shouldn't be viewed in isolation. Again, there's a lot of misinformation around things like marketing and consent for using people's personal data. Often it's not necessary. We need to also look at other legislation that's been around for a long time, like the e-Privacy Directive 2002, which governs the use of personal data for electronic communications and marketing. So we also need to pay attention to those other pieces of legislation as well, and just not look at GDPR as this entirely new thing looked at in isolation, and that's all that we need to do in terms of data protection. So we'll come on to those bits in a little bit more detail in a couple of slides. Okay, so to cover what is personal data, there is confusion around this as well. You see the term PII being bandied around a lot. That is a US-based expression, and it's much narrower in scope than the term personal data as defined by the GDPR. So Article 4.1 talks about personal data as any information relating to an identified or identifiable natural person. So it's quite important to break this down. So it doesn't just mean that collecting things that directly identify someone, such as their name, address, email address, or whatever else. It's also if you can infer something about an individual. So it can be indirect, and that's where the identifiable aspect of that sentence comes in. So as I said before, what constitutes personal data is wider than personally identifiable information. So, for example, in the GDPR, we have a new inclusion that IP addresses can sometimes be defined as personal data if it can be linked to another piece of data that could then identify that individual. So personal data can be as wide as, collecting someone's postcode, if that postcode only encompasses 10 households, and then you also have that person's age and gender and their shoe size. So anything that can be kind of aggregated together and that then makes that person identifiable. We also have what is termed special categories of personal data. So this is Article 9 of the GDPR. This used to be called sensitive data in the 95/46 EC directive, so you might still see that term being used, but it is now termed special categories of personal data. So this can only be processed in some circumstances. It has much more stringent requirements around it. So this includes data related to racial or ethnic origin, political opinions, genetic or biometric data, health data. Something quite important to know is that in the 95 directive, sensitive data was data related to a health condition. And now in the GDPR, it's stated as any data related to health. So again, it's much wider in scope. These special categories of data, processing them is generally prohibited unless you have, for example, the explicit consent of the data subject. And then there are other ways to do it through employment law or other statutory obligations, vital interests and so on. But these others will probably not be relevant for the market research sector on the whole. And so it will be explicit consent that we would probably need to look to if you are processing data related to any of these special categories. Okay, so moving on to just a general overview of the data protection roles and some of the terms that you might see being discussed. So we have a data subject. So that is the individual. It's a natural person as defined by the GDPR, and that person has to be living. So before birth and after death, not in scope of GDPR. We then have the data controller, the data processor. You will see the supervisory authority. So that's the regulatory authority operating in each country, sometimes also termed the data protection authority. And these are universal roles. So we'll see these in a wide range of privacy frameworks, legislation, codes of conduct. So it's not specific to the GDPR, but these are enshrined in the GDPR as well. So going into a little bit more detail, these are just the definitions as they are in the GDPR. So the controller is defined as the natural or legal person, public authority, agency or other body which alone or jointly with others determines the purposes and means of the processing of personal data. The processor is defined as the natural or legal person, public authority, agency or other body which processes personal data on behalf of the controller. So to go into a little bit more detail, data controllers, essentially, they determine the why and the how and what data are we going to collect, and for how long are we going to retain that data, where's it going to be stored, who are we going to transfer it to, by whom is it going to be processed, etc., etc. So they have wide legal obligations under GDPR. Controllers who employ a data processor to process data on their behalf need to conduct their due diligence on that processor. So that essentially means basically checking whether that processor has appropriate measures and safeguards in place to manage and protect that data in the way that they need to as required by the GDPR. So you need to conduct your due diligence, and then that needs to be contractually stipulated, or at least written down and agreed with that processor that in the way that they will handle that data. For bigger organizations, if you have the resources, you might want to go in and conduct an audit as well. Data controllers need to have a range of robust technical and organizational measures in place to protect data. So that means going further than things like information security controls. It's much wider than that. It's making sure that, for example, the employees working in your organization are aware of data protection and what they need to do. So it's awareness, it's training, it's, you know, so that's what it means by the kind of more organizational measures. So definitely don't ignore the information security side, but just know that that's only one principle in the GDPR, and there's a lot of other things that we need to think about as well. The data controller also has an obligation in terms of data breaches. So the data controller would need to notify the supervisory authority and in some instances data subjects as well in the event of a data breach. In the questions that come after this presentation, I'm going to come back to what constitutes a data breach and when would you need to notify someone of it. So we'll come back to that in a little more detail in the questions. One of the most important things that a data controller needs to do is ensure that they have transparency in place. So being transparent with data subjects about what is happening with their data, how they're going to manage it, how long it's going to be retained for, and all of those things. And that is upholding the rights of data subjects, which I will come to briefly in the last slide of this presentation. And then finally, a very, very important thing, a new principle in the GDPR, a term that has been around for a long time and a concept that's been around for a long time, but actually it is now enshrined as a 7th principle in the GDPR, and that is accountability. So that's about demonstrating compliance. So it is not enough to just be compliant. You have to be able, as the data controller, to demonstrate that you are compliant. So that means, you know, recording everything, documenting processes, you know, things that you've changed and upgraded and improved, and all of those things. So just make sure that any of the good work that you're doing is documented and written down. In terms of data processors, they also have increased liabilities and also a lot more duties under the GDPR than was in the 95 directive. Again, we need to see kind of adequate, robust technical and organisational measures in place to manage and protect personal data. Again, they are accountable and they need to be able to demonstrate compliance. In terms of data breach notifications, that would be from the processor to the controller, who then takes that forward in terms of reporting any data breach that needs to be reported to the supervisory authority. And data processors also have a requirement to assist the data controller with any data protection impact assessments that they need to carry out. If they get a SAR request, so that is a subject access request, which both data processors and controllers have to have a process in place for in case a data subject asks to see what data you hold on them. So the role is very specific to a processing activity. So you can be a data controller for one processing activity and a data processor for another with the same client. So it all really needs to be mapped out and recorded. It needs to be contractually written up, and what is on paper needs to match the reality. So it's no good just saying I would like to be the data processor and that's how we're going to write it up contractually. It actually needs to be thought about whether that is actually your role as defined by GDPR. There are also you know, other relationships, such as you can have joint controllers, you can have controllers in common who are essentially using the same data set but for different purposes. So a whole range of different relationships that we can have under GDPR. So I can't go into a huge amount of detail on all of these principles, but just to make you aware of the principles that are enshrined in GDPR and some of the things that we need to think about when you're developing your privacy program, your privacy framework, and your governance structures around personal data and data protection. So the principles are lawfulness, fairness, and transparency. There's also I will actually come back to the lawful and fairness in a little while, in a little bit more detail. So it's just, you know, this is ensuring that what you're doing with people's data is fair and legal, and that you have been, you know, open enough about why you're collecting and what you're going to do with it, etc., etc. Purpose limitation. This is essentially about collecting data for one purpose and then not using it for another. If you do want to use it for another, there are ways of doing that, but you can't just take a data set that you have and then use it for a completely different purpose. That would not be lawful. We also have data minimization and proportionality. So this is very important, especially if you're designing any kind of new projects or systems. You need to enshrine this value around just collecting what you really, really need in order to do the thing that you want to do. Accuracy, so this is ensuring that you keep any personal data accurate and up to date. Storage limitation, this is around retention periods and deleting data when it's no longer required. When you don't have a purpose for it anymore, then it needs to be deleted. Integrity and confidentiality, so that is keeping people's data safe, secure, confidential, not transferring it to people that they don't know about, that you haven't done your due diligence on, and so on. And then accountability, we've already talked about. So that is ensuring that you can show that you are accountable for how you're collecting and using personal data. I just want to touch on this briefly. So data processing includes a huge range of activities. So it goes all the way through from collecting and recording people's personal data to storing it and organizing it, and however you use it, whether you disclose it to another party, and then right through to when that data is you know, suppressed or erased or destructed, when you no longer have a use for that, you don't have a specific purpose for that data anymore. So just to make everyone aware that it encompasses all of these things. Okay, so moving on to lawful bases, and you might see this as legal bases or legitimate bases. So the term used in the GDPR is lawful bases. So prior to processing anyone's personal data, you need to ensure that you have your lawful basis mapped out, that you have a lawful reason for collecting and processing that data. So in the GDPR, we have 6 lawful bases that are described, and these are consent, contractual necessity, legal obligation, vital interests, public interest, and legitimate interests. Most likely, I think, for the majority of people on this call, coming from the market research sector, you would probably want to look to either consent or legitimate interests. So your lawful basis for processing needs to be per processing activity. So you can't just have one overarching basis for a company. So it needs to be per activity. So for example, per project, or if you want to market to someone via email, then those things need to have an established lawful basis. I just want to highlight these are not in order of importance. So consent is listed first, and it's often the one that people go to first, but that's not always the best idea, and I will come on to why. Okay, I think this is potentially the most important thing to understand for the market research sector, as well as legitimate interests. So consent under the MRS Code of Conduct, it's great, it's robust, but it is tailored towards research ethics. So the consent that is outlined in the MRS Code of Conduct falls short of the GDPR definition of consent. So if you follow the guidance for the MRS, which is great guidance, really excellent, and you will then be getting consent for conducting that research, project. So you need to be open and transparent about why you're collecting the data, etc., etc. But informed consent in a research ethics context and informed consent for data protection purposes is really not the same thing. It's not granular enough. It needs to be separated out. There are a lot of reasons why consent is quite a difficult thing to get. It's quite difficult to gain in practice. It's not as simple as just getting someone to tick a box. There's got to be a lot of stuff in the background, and then the privacy notice and how you outline what you're doing to that data subject, and ensuring that you haven't conflated informed consent for research ethics and then informed consent for data protection is vitally important, actually quite difficult to do in practice. And consent is void as a lawful basis if it's not rigorous enough. It can also be withdrawn by the data subject at any point, and there won't be an assessment of anything. It will just be that if consent is your lawful basis and it's outlined as your lawful basis, that if that data subject wants to withdraw that consent, then that is it, and the processing ceases. So it would certainly, my advice would be, and this is not legal advice because I'm not a lawyer, don't go for consent as the first option if you can look to something like legitimate interests instead. So to talk about legitimate interest, so this as a lawful basis is basically if the processing is necessary to meet the controller or the third party's legitimate interests. So that can be commercial interests, that's absolutely fine. It just means that you need to weigh up those commercial interests against the data subject's rights and freedoms. There's a three-part test on the Information Commission Office website, the ICO, so that is the UK regulator, and basically there's a lot more detail on their website, but these are the three main questions that you would want to ask if you're doing a legitimate interest assessment, as it's called. You would want to think about the purpose. Are you pursuing a legitimate interest? Secondly, is the processing necessary for that purpose? So that makes sure that we're thinking about things like data minimization and all of those important things. So is the processing of personal data really necessary to fulfill the purpose that you've outlined? And then thirdly, just do a balancing test. Get a few people in your company into the room and talk about, do we think that this is fair and lawful, and might the individual's interests actually override what we want to do commercially? So it's a discussion-based thing, and if you go through those steps, and there's more guidance on the ICO website, more in-depth questions. There's also a lawful basis interactive tool that's very helpful. And if you go through all of those things and you come up with an answer that you would like to have legitimate interest as your lawful basis, then you need to document that, essentially. So just make sure that you document. In the privacy notice, so this is your external facing document. This is to outline to data subjects what you're doing with their data. So it's vitally important. It's something that I see missing from the majority of privacy notices, that once you've established your lawful basis for processing, that you outline that really clearly to the data subject, that you say we're basing this on legitimate interests. These legitimate interests are these things. Just show them that you've thought about why you're doing what you're doing, and that you feel that it is fair and lawful. Privacy notices really need to be easily accessible. I see quite a lot written by lawyers, and potentially not the best thing, because we don't actually want any legalese. We don't want too many legal terms in there. It just really needs to be accessible and intelligible to the lay person, as concise as possible, while still covering all the things that you need to cover in a privacy notice. It needs to be free of charge on the whole, unless someone wants 10 copies of your privacy notice on paper and in the post, then you can start charging people. But essentially at the first point, it needs to be free of charge. You need to make sure that you have thought about and outlined the data subject's rights in that privacy notice. And the last slide that I'll come onto in a minute just outlines what those data subjects' rights are. And then outlines data breach notification. So what are you going to do in the event of a data breach, and how will you inform that data subject? Oh, I forgot to say, sorry, on that last slide, the privacy notice, again, there's great guidance from different regulators across the EU. The ICO has a very, very good document on how to draft a privacy notice. So it's really definitely worth a look. Okay, so finally, just to cover, in the same way as the overarching principles that are embedded in the GDPR that I covered earlier, data subjects' rights need to be thought about, and they need to be protected throughout any personal data processing. So these are the right to be informed. So this is about transparency. That data subject has the right to be informed about why you're collecting their data and what you're going to do with it, etc., etc. The right of access. So this is enabling data subjects to be able to access whatever data you have on them. So that is a SAR process, a subject access request process, for example. So you would need a form available on your website or whatever else, where someone can fill in their details and ask to see whatever data you hold on them. The right to rectification. So this is if any data is deemed to be inaccurate, just wrong, that data subject has the right to ask you to rectify and correct or amend that data. The right to erasure. So in some instances, that data subject can ask you to delete the personal data that you hold on them. They would need to have a reason for that. It would need to be assessed, but they do have that right. The right to restrict processing. If a data subject feels that the data processing that you're doing is unlawful or unfair or untransparent or any other number of reasons, then they have the right to request that you restrict processing while their complaint or their issue is assessed. The right to data portability, this is a new right under the GDPR. So this is a right for a data subject to have their data transferred in a portable way from one data controller to another. So for example, if you're changing mobile phone providers, then you have an easy way of requesting that one data controller transfers all of your information that they hold to the new data controller that is needed for you to then set up a new contract with that new data controller. The right to object. In some circumstances, the data subject has a right to object to processing. So for example, there is only one absolute right enshrined in the GDPR, and that is the right to object to direct marketing. That is a right that any data subject in the EU and the EEA has to object to direct marketing and for that direct marketing to cease. And then finally, data subjects also have rights in relation to automated decision making and profiling. So automated decision making can only occur in some circumstances, and profiling as well. It's not banned outright in the GDPR, as I have seen written a few times. It's not. It just needs to be balanced against the data subject's rights. And the data subject also has the right to not have a decision made that's just an automated decision without having access to a human person. And that human being, that person needs to be able to change a decision. So it can't be someone who holds absolutely no power or sway. So for example, if you go through an automated process for your car insurance and it comes back with a price that you don't think is right, or they just won't provide insurance in general, and that's an automated decision, you as the data subject would have the right to have human intervention on that process. So I hope that's not a bombardment of way too much information, and I hope I've covered the kind of main things that we need to think about when we start thinking about GDPR. So I think we will now move on to some of the questions that we've had in.
Yeah, we will. Thanks so much, Inga. That's wonderful. Wonderful. Thanks so much, Inga. I think that's probably all we've got time for today. But if you'd like to discuss anything that we've covered, please do contact Inga directly. I've got her email address up on the screen for you there, or via LinkedIn as well. Just a reminder, we are sending out a recorded version of the session, minus the Q&As we've just discussed, and hopefully re-recorded the beginning. So if you do want to find out what you missed in that section, we will do that for you, together with slides, so that'll come out in the next few days. Do keep your eyes out for that. All that remains is for me to say thanks again to Inga. It was really wonderful on behalf of everyone at Liveminds. Thanks for joining us, everyone, and enjoy your day.